Welcome to today's meeting. This is the appointed time and we have a quorum. So I call this meeting to order. First item on the agenda is to elect a deputy chair. Before the meeting, the Secretariat already informed members that one valid nomination for deputy chairmanship has been received. The member so nominated is Mr. Dennis Leung. According to the House rules, I need to ask members if, first of all, members agree to elect a deputy chairman. Any views? All in support? All right. In that case, I declare that Mr. Dennis Leung is returned Deputy Chair of the Subcommittee on Residential Care Homes Elderly Persons Amendment Regulation 2026 and Residential Care Homes Persons with Disabilities Amendment Regulation 2026. Thank you, Mr. Leung. So let's invite the administration to come in. Please note that we are now examining two items of subsidiary legislation, and that's Residential Care Homes Elderly Persons Amendment Regulation 2026 and RCH PwD Amendment Regulation 2026. The purpose of the amendments are to introduce a new professional rank of health and care practitioners for the social welfare sector. Now, before we start our discussion, let me ask members if you'd like to invite written views from the public on the two items of subsidiary legislation. Any views? Just written views will do? All right. We'll send the invitation. In that case, the Secretariat will put up a notice on LegCo's website, and the 18 district councils will also be informed. And then the views collected will be forwarded to the administration for a consolidated response. Next, I will invite the administration to explain the policy behind the two proposed amendments. And members, if you want to speak, please press the request to speak button. I'll now give the floor to Mr. Ho Kai Ming, the Undersecretary for Labour and Welfare, to walk us through the proposals. Good afternoon, Chair, members. I'm going to explain the Residential Care Homes Elderly Persons Amendment Regulation 2026 and Residential Care Homes Persons with Disabilities Amendment Regulation 2026, including the background and the highlights of the amendments. There are 1,200 residential care homes for the elderly and for the disabled persons, respectively, looking after 85,500 residents. And at the moment, approximately 5,000 nurses and health workers, care workers are employed in the system to provide suitable and quality care to elderly and persons with disabilities. And there is a long-standing challenge of attracting new blood and retaining talent. The Social Welfare Department earlier commissioned a consultant to conduct a review, and according to the consultancy study report, in terms of a professional pathway for the personnel, enrolled nurses have similar duties with health workers, and upon further training and accreditation, health workers can actually take up more of the duties of EN, and that is why, according to the consultancy study report, there is a recommendation to create a new health care professional, and that's HCP professional rank for healthcare sector. The professional rank will be dedicated to health and care work in the social welfare sector. There will also be new training courses designed, followed by registration and regulation mechanism. We believe that this new professional rank will help attract dedicated individuals to join the social welfare sector. And there will also be better career prospects for the health workers in the industry, and this will help stabilize the supply of manpower so that we don't need to compete with the healthcare sector for nursing staff. Under the current legislation, there are staffing requirements as well as a licensing mechanism for RCHE and RCHD. We propose to amend the respective legislation, and that's 459A and 613A, by amending these two regulations, we will introduce the new professional rank of HCP, and that the staffing requirements will also be applicable. But this will not apply to other new positions. There are three major amendments. First, to set up a registration system for HCP, and second, to make sure that without changing the current staffing ratio, HCP will be included in the minimal staffing requirement of residential care homes. And third, we will also amend the basis of calculation for the HCPs needed, so that instead of counting the number of beds, we will have regard to the number of residents in the residential care home. Now, the new amendment regulations will cover registration, renewal of registration, cancellation, and appeal arrangements. And then there will also be the Social Welfare Department in charge of registration, assessment, and handling of complaints to ensure that the new rank of HCP will be effectively regulated and monitored. We emphasize that for the provisions for the new registration system of this rank, they are on a par with the existing registration mechanism for health workers, and that the system has been running very smoothly. The second point is we also propose to amend sections 10, 11, as well as Schedule 1 according to the recommendations of the consultancy study report, so that the statutory staffing requirements will also cover HCP, and that means upon the amendments taking effect, the operator of the RCH can hire either enrolled nurse or HCP in order to meet the existing staffing requirement, unless there is a specific requirement for enrolled nurses, and in that case, the HCP cannot replace the EM. According to the passage of the Miscellaneous Amendment Regulation 2023 in June, the new requirements will come into effect from June 2028 and the date to be specified by the Secretary respectively. We are going to include the provisions relating to HCP in the amendment ordinance to make sure that the RCHs will be able to employ ENs or HCPs to fulfill the statutory requirements. The third point is that we are going to change the basis of calculation of staffing requirements for nursing homes from the number of beds to the total number of residents, so as to align with international practice as well as the staffing requirements for residential care homes of other care levels in Hong Kong. Now, this already applies to LCH of other care levels, and the sector is very familiar with this arrangement. We share the same view of the subcommittee. We attach great importance to the competence and the quality of service of HCPs. So we're going to introduce a registration system, and that only applicants meeting the qualification requirements will be able to be registered as a registered HCP, and that it means the candidates must first complete the professional diploma course, and this is pegged to the other similar courses for enrolled nurses, and that for care workers in the social welfare sector, they need to go through similar assessments, including a written and exam practicum, and they will also be required to pass the assessment of certain core competencies, such as changing the ureter, as well as injections and extraction of sputum, and the certificate will only be issued upon completion of these tests. We consulted the panel on welfare services on 2 occasions, and we had garnered the members' support. As for details of the relevant provisions, we're going to explain further. So feel free to ask questions. Welcome. Your comments and questions are welcome. Thank you. Thank you, Undersecretary. 6 members have signed up to speak. Let me read out their names. 7 altogether, starting with Professor Chen Wing-Kwong, Chow So-chung, Andrew Lam, Len Chum-sing, Lam Wai-kong, David Lam, and Elaine Chick. I will give each member 4 minutes question and answer, starting with Professor Chen Wing-kwong. Thank you, Chair. I'm happy to see that there is a new way of recruiting staff so as to meet the manpower challenge facing residential care homes. But I have the following questions. First, upon introducing this new rank of HCP, I'd like to know the division of work and the respective roles of registered nurses, enrolled nurses, health workers, and care workers in the residential care homes. In other words, what duties can only be taken up by RNs and ENs and not HCPs? The second point is that in terms of the two pieces of subsidiary legislation, it is proposed that HCPs can be employed in place of enrolled nurses in order to meet the statutory staffing requirement. Now, does it mean that HCP can be hired in order to meet the staffing requirement instead of enrolled nurses? For example, according to the residential care home ordinance, we need the presence of, say, an enrolled nurse. Is it that upon passage of the amendment regulation, as long as the HCP is present, it will suffice? Because in that sense, how do we make sure that the HCPs will be properly trained and accredited, and that they'll be competent enough to go through high-risk procedures and provide adequate care to the residents? My third question is, how does the administration gauge the result? That is, after introducing this new rank, will there be any indicator to show whether it's effective in attracting new blood? Say, in the coming 5 years, how many more registered HCPs will come onto stream? Now, apart from professional skills, you also need to build the career pathway in order to retain staff. So the next question is, how will the government subsidize the residential care homes to make sure that the remuneration levels remain reasonable without adding to the cost of RCH, and that the position of HCPs will remain competitive? I'll try to answer the last question, and then I will invite John, my colleague, and as well as Mr. Wong to take the rest. About remuneration for subvented homes, they go under the lump sum grant system. And as for remuneration, we rely on the market mechanism. We are only talking about the minimum requirement. So if they have additional manpower on top of meeting the statutory requirement, then that's because they want to provide quality services. It's for them to take costs into the calculation. Now, on the whole, we are going to provide additional resources, but in the end, it depends on demand and supply and how the market works as well. In fact, for the first phase, we've received applications from several hundred applicants. It will take time to fully implement the arrangement. Mr. Wong can supplement, or Ms. Wong can supplement in a moment. The point is, with more health workers or care workers in Hong Kong, we want to provide another rung on the ladder so that they can be promoted to HCP before they become, say, the home manager. Because in the future, there'll be millions of people in Hong Kong who are senior citizens with demand for care home services. And if we're not able to retain talents for individual homes, then those who offer higher pay would definitely be able to attract talents. So I understand members' concern on the pay for HCPs. We need to strike a balance, because if we offer a higher pay, this may have an impact, cost of brain drain in hospitals, and vice versa. So we need to conduct further assessment on the pay level. I'll elaborate in a moment. So in short, we will rely on the market to adjust the pay level. I don't think the sector prefers to hire imported labor. I remember only receiving several hundred applications for enrolled nurses. And that is why, from outside Hong Kong, and that is why there is a need to groom local talents. I'll give the floor to the Permanent Secretary to take the other question. Let me also supplement in relation to Professor Chan's question in terms of the respective roles and the duties. The HCP that we have in mind will not replace the rank of EN. It's just that they'll be interchangeable. And that means what they have been doing in hospitals will similarly be applicable to the residential care home setting. We're providing more flexibility to residential care homes. In other words, the operator can hire either an enrolled nurse or an HCP, and that is flexibility. And that means we'll be able to build a wider talent pool. There'll be increase in manpower supply, and there'll be more flexibility in operating a home. And on the whole, this will bring benefit to the sector. So I emphasize that these roles are interchangeable. They're not replacing each other. In the future, they can take up the same scope of duties, EN or HCP. But for registered nurses, that's RN, that's not the same. I'll take the second question. That's about pay. As these roles are interchangeable, there will not be additional or reduction of resources for subvented homes, because same resources go to subvented homes to hire HCP. It's not a way of cutting costs. This is not our intention. We just want to provide flexibility for the sector and to help them nurture talents. We are not going to slash funding, but for pay level, I think it will be left to the market. Effectiveness of the policy and indicators. In fact, recently we conducted a questionnaire survey. In the coming 3 years, 900 people have expressed interest, and they meet the eligibility requirement for taking these courses. So, as we explained at the panel meeting, we are going to have, for the first cohort, 2 classes with 30 students each, and we'll keep things flexible. We'll respond to market needs. And I'll now give the floor to the director to explain the role of RN.
Let me supplement concerning the code of conduct and also the legislation for the inmates of residential homes, because they do require a high level of care. And that's why in terms of the legislation, it already specifies that a registered nurse must be the manager. And also in terms of staffing level, there should be a higher number of registered nurses. And for the code of conduct or the code of practice, now for more complicated procedures, such as the changing of catheters and so on and so forth, such complicated duties will have to be performed by RNs. Mr. Zhao Xiuchong, I support the idea of creating HCPs so that there is a clearer career path for the present health workers and care workers, so that it offers long-term attraction to potential talents. I've got several questions concerning HCPs. I'd like to ask about supervision and the quality assurance of such a grade, because they will come under the Social Welfare Department. Now, for registered nurses, they will come under the Nursing Board. Whether it's registered nurses or enrolled nurses, the Nursing Board has got a very clearly regimented mechanism for registration and cancellation of license and so on and so forth. I'd like to know whether the same clear-cut mechanism will be set up for HCPs for supervision purpose. My second question has to do with remuneration. The Secretary just now has already given some explanation, but I'd like to follow up. Indeed, you will continue to provide one-off subvention to NGOs. And NGOs at present follow a pay scale that is kind of comparable to Social Welfare Department's pay scale. And they take reference from Social Welfare Department's pay scale. And so each grade will be eligible for certain pay points. And the present thinking is that the training course will be open for health workers with 3 years experience. And after completing the training, then they will be qualified as HCPs. So there should be a new pay point that is pegged to the HCB pay point. At present, health workers is at 7 to 15 points. And enroll nurse also starts at 0.7. Now, if HCP is also pegged at this point, then because the requirement is that HCP's training will only be open for health workers with 3 years experience, and yet if their pay points are pegged at the same level, then I don't think it will be attractive enough. So I want some explanation from SWD. You say that you want to attract more young talents into this pool. In the year 24-25, there has been this launching scheme for attracting young people into the care workers rank, but it doesn't seem to be especially successful. So isn't it now a very good time for you to review that particular launching program so that you can align that particular program with the HCP new career progression path so that it becomes more attractive to young talents? Secretary first, and then the department. I thank Mr. Chow for his opinion. Indeed, we are very mindful of the need to supervise the quality and to assure the quality of HCPs. Now, if you talk about quality, first of all, one particular level of assurance is the qualification for admission to training. And the qualification will be the same as EN. And also, the requirement is that the health workers must have 3 years of experience at residential homes, not clinics, and so on and so forth. And so they must have had experience already at residential homes. And so that's relevant. And so that's another level of assurance of quality. And thirdly, upon graduation, they will have to go through the same examination as an EN. It's comparable. I'm not talking about hospital work. I'm talking about residential homes work. Now, to put it simply, say an EN will have to master skills in, say, 18 fields at an hospital before graduation. But for an HCP will only have to pass the examination for the skills that are relevant to our age, not a hospital. And so it will be smaller in number in terms of number of skills. And after they have reported to duty, then they will come under the supervision of SWD, and there will be appraisal to make sure that the HCP's quality is being assured. And Mr. Zhao has also mentioned that EN comes under the nursing board, and nursing board has a well-regimented mechanism for supervision, such as disciplinary hearings and so on and so forth. Will the same be provided for HCPs? Now, for medical field, indeed, things will be much more complicated and much wider in scope. But for residential homes, the complexity of duties and the requirement for professional efficiency or professional efficacy is not comparable to that for a hospital worker. And so we have to come up with a scheme that is commensurate with the requirement of residential homes. We don't have to make it as complex as an EN's supervisory regiment. And also SWD in any case will supervise the HCPs. Now thirdly, about remuneration. As I said earlier on, we will not increase or decrease the level of subvention for NGOs because of the creation of HCPs. The policy objective is to create a new grade, HCPs, and their duties are complementary and comparable with that of ENs. And so the pay level will be comparable to EN as a broad principle. But the market will ultimately decide the appropriate level for HCPs. And we also look at the admission situation of HCP trainees and see how the market response is. And we do not rule out the possibility of creating more schemes in order to attract more talents to come into this trade. SWD, would you like to add? Thank you, Chairman. Indeed, I would like to add. Now, concerning complaints against HCPs, actually, under the SWD, there will be a special inspectorate grade to look at this grade. They will look at complaints. They will handle complaints, and such an inspectorate grade will comprise a registered nurse and registered nurse administrators and so on and so forth. And so they are professionally qualified and they are very experienced. And at unannounced time, they will carry out spot checks on the residential homes and also will keep liaising with the trade to make sure that the HCP's quality will not drop. And as for remuneration, as Mr. Chong has already pointed out, ultimately it will be determined by the market. But for subvented homes, we will very actively incorporate HCPs into our pay scale so as to give it due recognition so that we can attract more people to enter into this profession. Thank you. I would like to follow up a little bit on this. Now, for remuneration, you say that it will be incorporated into the SWD pay scale. I'd like to know, do you have a rough estimate as to what is going to be the starting pay point? Thank you for your question. At present, the EN's present pay scale is 7 to 15. It's 22,000 to 47,000. Now, for HCP, our present thinking is that we will take reference from this particular range. So they will be the same as ENs. But at present, health workers is also starting at the same pay point. Now, for health workers, it's 7 to 15. And they start at the same point, 22,000, but they end earlier at 35,000, not 47,000 of ENs. Next member. Indeed, I fully recognize that HCPs is a different grade than nurses. However, as also has been pointed out, nurses and HCPs are mutually replaceable. And so you have to take reference from the situation with the nurses. Clause-by-clause scrutiny might not be sufficient to deal with matters of principle. And so I would like to take today's forum as an opportunity to clarify one point. Now, the two grades are supposed to be mutually replaceable, and yet they are two separate grades. And so how do you strike a balance between the two? Now, for nurses, registration ordinance, whether it's registered nurses or enrolled nurses, they come under life tenure. However, for HCPs, it's on a contract system and it's subject to renewal every 5 years. Now, if you say that ENS as well as HCPS are doing essentially the same duties at residential homes, how come they come under different length of tenures? And also for Cap 164/25, the nursing board if a nurse has contracted contagious disease, then the board can ban this infected nurse from looking after patients. However, nothing like that exists for the governing of HCPs. Say in a residential homes, if there exists side-by-side ENs as well as HCPs, and if such an EN in a residential home has contracted an infectious disease, then the EN could be banned from looking after inmates. But the same will not happen to the HCP. How come there is such a discrepancy? Thirdly, in extreme circumstances, exceptional circumstances, such as the follows. Now, for nursing registration ordinance, any person is forbidden from passing himself or herself off as a nurse. Now, this is clearly specified under the ordinance. However, if someone is working at an elderly home or a disabled home, if the duties are mutually replaceable between two grades, an inmate cannot distinguish an HCP from an EN. The inmate will only call for assistance, and he wouldn't care whether an EN or an HCP comes to his or her aid. Now, this, of course, might be an extreme circumstance. However, I think still there is room for you to clearly sort out that under such a circumstance, the health worker or an HCP might be passing himself or herself off as a nurse. And so this has to be sorted out. Now, next point is about insufficient staffing level. I'm talking about staffing level. I'm not talking about level of experience. Now, why is it that one registered HCP or one registered nurse can replace two HCPs?
The Secretary. Just say a few words and then I will ask my colleague to supplement. Now, I won't say it's impersonation, but, you know, in an elderly home, the elderly usually would just call every staff member a nurse. So, in general, I mean, regardless of whether this staff member is actually an HCP or a care worker or health worker, say, this tubing seems to be loosened, please help me, nurse. And I believe, be it the HCP or the health worker, they will need to fulfill their duties. So they're clear about their scope of duties. And that I'm not quite sure about the situation you mentioned, but then the staff will of course be sure about what they need to do in order to perform their duties. And there'll be a very clear delineation. The second point is this, about this, I mean, Mr. Andrew Lam was there when we amended the residential care home for the elderly ordinance. We changed the registration period for health workers from live registration to a 5-year period subject to renewals. Now, we don't want any misjudgment because there are so many similar titles for staff claiming to be health workers. and that indeed we've learned from the sector that there are recruitment difficulties. That is why we put in place the 5-year registration mechanism without having too much impact on the sector, we hope, because for social workers, as you know, they need to register and renew their registration every year. So we want to strike a balance by setting a 5-year registration period. As for infectious disease, I will ask Mr. Zhang to supplement. Thank you, thank you, Chair. Thank you, Mr. Lam, and do allow me to explain from our perspective. Nurses are not trained just to work in residential care home sector. Nurses can work in the healthcare sector. However, we do need healthcare talents in residential care homes as well. So in hindsight, if we were able to establish ranks similar to, say, an HCP, then we will be able to set up professional ranks tailor-made for the care home sector, and that we will not be relying on nurses as the only source of manpower supply. But then because of the interfacing issues, we introduced the licensing mechanism for care homes, and that for certain duties inevitably, for expedience, we had to ask nurses to take up these duties in care homes. But in future, if we're able to provide a dedicated stream of talents for the social welfare sector, then that will be self-sufficient. Mr. Andrew Lam referred to regulation of nurses. This applies to, in theory, the healthcare sector. There may be different requirements. However, as I explained just now, we introduced the HCP rank, especially to meet the needs of social welfare sector. So it's comparable, but it may not be suitable to compare directly. As for these roles being being interchangeable, it doesn't mean that the social welfare sector should just copy the whole mechanism from the healthcare sector. So I hope members would appreciate that. The other question is, if I get it correctly, about one nurse being equivalent to 2 health workers. Of course, it's not physical equivalence. We're not talking about a pair of hands being equivalent to 2 pairs. We are referring to flexibility in terms of staffing requirements in general. Say, for a care home with 180 residents, that means 6 health workers will be required. But then, if we are so rigid as to specify 6 health workers and not any other possibility or combination, then there'll be a lack of flexibility. Whereas if you allow, say, the presence of a nurse, so that a team can comprise a nurse and 4 health workers, then you can still provide very good care for the residents whilst maintaining flexibility in the establishment. It's not a direct physical comparison. Well, I think Mr. Lam is referring to the fact that it's not fair. Why is it that 1 nurse equals 2 health workers? Your understanding may be that basically for ENs and HCPs, because of their interchangeability, in some ways is 1 is equal to 2, and then that gives an impression that 1 EN equals 2 health workers. So that's the impression that people have. There is an impression that EN is actually a more competent staff than health workers. Well, let me explain my point. I believe I know that you're emphasizing these are two different systems with some replaceability in terms of EN and health workers. But in reality, there is still the perception of 1 equals to 2. And there is a gap in terms of the message you send out. I fully support the government's efforts in promoting the development of this profession, but I think in terms of the message you give, you need to make sure that this is sent out correctly. Do allow me to supplement. 1 EN equals 2 health workers, indeed, but we're talking about this new rank of HCP. Like Mr. John, the Deputy Secretary, said, the HCPs will receive dedicated training to work in residential care homes. So in some ways, it's equivalent to nurses. Say, I can use this analogy of the World Cup. Well, this football player can take different roles, but if we're talking about a nurse, but for HCP, we have a dedicated scope of duties. Not only, perhaps only for the defense or midfield, and the HCP cannot replace a nurse in hospital, for example. So from this perspective, you can only say that in a residential care home setting, 1 EM may be equivalent to 2 health workers, but for HCP it's something different. As for the pay level, I think that we should leave it to the market, because say if this is a very competent footballer who is able to take up different places, then of course the MVP would be higher. So that's to answer the member's question. Do you accept that? Well, as long as the public understand. Let's put it this way. We keep on referring to the EN, and I think it's quite confusing. We need to make it clear that definitely these two are not equal. We need to explain to the public that as far as the residential care home setting is concerned, some of the duties originally taken up by the EN can now be covered by the HCP. That's all. Mr. Lam Chun Sing. Thank you, Chair. Now, the government already explained that for EN and HCPs, these are interchangeable, and the operator can choose which to recruit. And that means some homes can now leverage on the labor importation schemes in order to recruit non-locally trained enrolled nurses. That's for meeting the statutory staffing requirement, and that there is no need to hire local HCPs because these are replaceable. So for the skilled professionals under the tenant admission schemes, you've received several hundred applications for enrolled nurses. Not large number, but we need to keep in view the situation, because for the pay scale for HCP is proposed to go from 7 to 21, and the median means some $30,000, whereas for non-local nurses, the market rates are actually $22,000 at the moment. So if these non-local nurses are preferred by residential care homes in the future, then these positions will be filled. All the work will be taken up by them, and that even for locals having studied the professional diploma course, they can't become an HCP. I want to make sure that you will keep this in mind, and that after taking these courses and becoming HCPs, our local workers will still be able to get a job, and that the care home operators must show proof that they have recruitment difficulties before they're allowed to hire non-local enrolled nurses. I know that there is administrative measure from the Labor Department, so please keep that in mind. The second point is that after all, I do believe these are different positions. You explained that for nurses, it's for the healthcare sector as a whole, whereas for HCP is a tailor-made role for residential care home sector. But there are still requirements before being admitted to take the courses, say DSE requirements. Is there any discretion to allow in-service health workers who do not meet the basic academic qualifications requirement to take the professional diploma courses? Or we do have some new arrivals in Hong Kong who used to work as nurses in the mainland. It's very difficult for them to sit for the nursing exam in Hong Kong. They do have experience of working in hospitals, but they do not meet the DSE requirement. So again, will there be discretion for them to sit in the exam and see if they are capable? Well, Secretary, thank you, Chair. I will explain the manpower demand and then I will see if my colleagues would like to supplement. On manpower demand, we have yet to reach the peak, as I said in the opening remarks. We already have a manpower shortage, and we do have some upcoming requirements by June 2028 for residential care homes with over 60 residents. There should be at least one nurse, or in the future an enrolled nurse or HCP. So in theory, even for homes housing 60 residents or less, they should have an enrolled nurse or an HCP in the future. Now, what about the manpower situation? We have 480 enrolled nurses, but then because of attrition, retirement, switching to other fields, we need 890 ENs. And according to the Miscellaneous Amendment Regulation 2023, we need 190 more ENs in order to meet the new requirements. So on the whole, according to our calculation, we need 2,140 ENs without introducing HCPs. The Social Welfare Department has a subsidy scheme, and that local students can take this course to become ENs, and we're talking about 1,700 places in a four-year course. Taking everything together, we still need 440 more, and that means we need to introduce the HCP professional rank in order to meet the demand. I'll see if Mr. Zhang would like to supplement.
Now, concerning demand, as the Deputy Secretary has already pointed out, all along, the industry would like to recruit sufficient talents locally. For imported nurses, they will only be brought in as a supplement when there are no further options to recruit local talents, and so priority will be given to local talents. Now, after the HCP scheme is implemented, I'm sure the industry would be very willing to give local talents a first bite at the positions without resorting to imported talents. Now, for qualification, we have taken reference from EN's requirement for qualification for HCP because as far as residential homes are concerned, HCPs and ENs are supposed to be mutually replaceable, and that's why we have taken reference from ENs academic qualification, for setting the academic qualification for HCPs. We do appreciate that there may be a pool of people that are academically and in terms of experience qualified. But at present, they are not in the residential care industry. And so we want to create opportunities for them. And at the same time, we want to ensure the quality of staff because public's confidence depends on that. And if we do not really have a very strict requirement for academic qualification, then it will not inspire public confidence. And that's why, in terms of academic qualification, we want to peg it to ENs. And training level, we want to peg it to the EN. We do understand that outside talents might have different ways of manifesting their qualification. They may have different qualification standards and so on and so forth. However, we do have academic qualification accreditation authority in Hong Kong, and so their help can be sought. Indeed, there are not many non-local nursing talents coming into Hong Kong, and so the situation is not especially bad. However, for every 10,000, you create a quota for 3,000 important nurses. And if all 3,000 of them come into Hong Kong, then it might create difficulty for locally trained HCPs. They may have difficulty in finding jobs. I do support the proposed amendment in creating the HCPs. Earlier on, I've heard that in the nursing profession, there is noise saying that there is insufficient career progression path. And so I think it's a good idea to create such a new grade to attract new talents and also to create a new path for career progression for existing health workers and care workers. So that's a good idea in that sense. However, remuneration is a very relevant point. Now, whether your remuneration is attractive enough. Now, for existing health workers, and they might be eligible to become HCPs after having accrued 3 years of experience. However, the precondition is that HCPs' remuneration must be attractive enough for that to happen. At present, the Bureau says that the pay point and the pay scale will be closely akin to ENs. And you also say that it will be ultimately determined by market supply and demand. Is it possible for you to, after this scheme is in practice for, say, a couple of years, when everything is mature, you can carry out a review so that you can see whether the remuneration package is appropriate and at the same time come up with an attractive enough remuneration package if it's not attractive already enough. At present, for HCP, the training hours is around 700. For ENs, it's around 2,000. Is it possible for an HCP to make up for the shortfall in training hours so that they will become ENs and so on and so forth? Because at present, young talents may first of all enter the profession as health workers and then progress to HCPs and then to nurses. As the Bureau has pointed out, in terms of exact line of duties, HCPs in practice don't have to perform as many duties as ENs. And also their level of expertise is kind of lower than ENs. Now, is it possible for you to make it possible for HCPs to progress to nursing grades so that the HCPs will have another choice of progressing in their career path? Thank you for your question. We want to create this new grade because we want to separate it from the medical talents pool. Now, if you say that the two should be converging, say after HCPs have completed the training and after making up for the shortfall in training hours between HCP and nurses, and they would progress on to becoming nurses, then that is really not our intent. Of course, it is always a choice. If they want to leave HCP's grade and they want to sit for training for nurses and eventually becoming nurses, and that is something that we would not forbid. But that is not the original intent of creating the grade of HCPs. As for remuneration, I do understand that the proposed starting point is HCPs being the same as ENs. However, their peaking point will be different. Now, if someone is capable enough, then of course he might want to choose a position that will have a higher or greater range in terms of pay progression. And eventually, as I said, the market will determine the pay level. I don't know whether the department has anything to add. Now, concerning HCPs progressing onto being ENs. Now, our intent is to train specialized professionals for residential care services. Now, if RCPs would like to progress onto ENs, and in the course of so doing, is it possible to exempt them from certain training because they are already HCPs? Now, this is not something that is up to us. And also, you have to be mindful of our original intent. Our original intent is to create specialized professionals for residential homes specifically. As for whether they can, after making up certain shortfall in training hours, can become qualified for nurses, then that would be up to the nursing profession. After the amendment, HCPs can also progress to become managers of a residential home, and so there is already sufficient room for career progression. Thank you. I would like to make a response concerning staffing level. I don't know whether the Deputy Secretary is aware that every year 5,000 nurses have completed training at a nursing training school, ENs and RNs included. And every year we only have 30,000 newborns. At present, the wastage rate is around 10%, around 3,000. And so it takes only 1 year for you to make up for that shortfall. And so in the long run, I really don't see that there is the prospect of shortfall in the supply of nurses. But of course, the caveat is that not all nurses would be willing to move into the residential care services. The medical profession as well as the care profession are evolving constantly, and new technologies for both are being created for both professions. And so in-service training is a must, and refresher training is a must. And also for relatively more complex procedures such as intubation of a catheter. Now, even in the medical profession, even in hospitals, mishaps can happen. So these are high-risk procedures. I'm not saying that HCP, after receiving such training, must perform such a duty. But is it possible for you to create a code of practice saying that under certain circumstances, say under supervision, an HCP can perform such higher risk duty? And also in emergency, can can you specify what kind of emergencies would require the HCP to perform such duties on their own? And so there should be such a code of practice for the residential homes. The universities, of course, will be teaching a certain regiment for that kind of duties, but you don't have to follow it to 100%. And also, it has to be constantly reinvented and also constantly revised in order to meet the needs of time. And so I think you really have to give regard to that so that safeguards can be put into place so that such higher risk duties can be performed in a safe and supervised manner and regulated manner. Earlier on, I heard from the Bureau saying that HCPs are performing the same duties as an EN in a residential home. This is something that worries me. But the Secretary subsequently clarifies that that is only so in the context of the residential homes. It doesn't mean that HCP is completely the same as an EN in all contexts, because we don't want society to misunderstand that HCPs are completely the same as ENs, because if that is the case, then the nursing profession is going to kill me, because nurses have to undergo much more training than an HCP.
Right, I'll let Mr. Zhang speak first. Let me explain continuing education and then the handling of high-risk procedures. The Deputy Director can take that question in a moment. On continuing education, we do have a plan. In fact, we have made provisions in the bill and that the Director will be empowered to impose conditions in the process of registration or renewal of registration of HCP. However, we're talking about registering the first batch of HCP, which will come onto stream soon. We've yet to reach a stage of continuing education. We need to gauge the implementation and the needs of the sector. And we don't rule out introducing the CPD requirements in the future for new registrants or those seeking renewal of registration. Because after all, HCP is something new. You should allow, say, a few years after the candidates have completed the course before introducing the continuing education requirement. About the high-risk procedures, I'll give the floor to the Deputy Director. I'd first like to talk about the continuing education aspect or continuing professional development. This is a new rank. We need to see if this should be included in the framework later on. But we're concerned about the professional level of the HCPs. Upon graduation, but we're actually exploring other courses as CPD for them. For high-risk procedures, the HCPs will need to follow the codes of practice or guidelines promulgated by either the Department of Health or the hospital authority. We also understand the sector's concerns. We are going to review some internal codes to make sure that the code of practice will be enriched to cover these aspects. Ms. Elaine Chick. Thank you, Chairman. I support the legislative proposal because the proposal seeks to introduce additional manpower to address the need of residential care home sector. On remuneration, other members already asked the relevant questions. I've heard the explanation from the administration. Now, I'd like to focus on another proposal, and that is to change the basis of calculation from the total number of beds to the total number of residents. So for care homes with low occupancy rate, will there be an excuse for the operator to make their staff redundant, and that will cause fluctuations? And how do we prevent that? Because there may be fluctuations in the occupancy rate of care homes as well. And the Secretary. I think this is actually applicable to nursing homes. For other homes, I think that they've adopted a new system of using the total number of residents as the basis. Well, this only applies to nursing homes. At the moment, the basis of calculating the staffing requirement is the total number of beds. For nursing homes with high level of care, the system will change, and that the total number of residents will form the basis. But nursing homes do have high occupancy rates. They are usually full. There should not be great fluctuations of the staffing level. Anything to add from the Deputy Secretary, please? Yes, do allow me to supplement I'd like to explain the rationale. We are going to rationalize the staffing requirement, and that the total number of residents will be used as the basis of calculation. We need staff to look after the residents. Say if I run a home, it takes time for residents to move in. Say if I have 200 places, I can't recruit all the staff before the home is commissioned because it's not practical. At first, I may not be able to attract 200 residents. We should allow flexibility, and that is to allow them to take in residents and hire staff at the same time. And the second point is this change will apply to nursing homes with almost a full occupancy all the time. So I don't think there will be any downsizing. Next, Mr. Dennis Lau. Here is my concern. The HCPs will need to undergo training. Now, the relevant requirements are 3 years of experience for in-service health workers, and then they will be eligible for further training, and that means 760 hours of learning at least, which covers 480 hours of in-class teaching, followed by 280 hours of practicum. So is it going to be a full-time course or a part-time course? Because if you're an in-service practitioner, it won't be possible to take up a full-time course. If it is a full-time course, will there be ways for the students to work around the class schedule? Will there be further communication with the care homes? And it's such a long course. Now, by simple math, 480 hours in total. If you take a 3-hour class, 5 days a week, that means 32 weeks in total. And that's quite hectic. I'd like to have more information about the training courses. Let's see who would like to take this question, please. Mr. Zhang. 760 hours of learning, comprising 480 hours in class and 280 in practicum. So it's actually a part-time course, whereas for practicum, it will be counted towards a full-time basis. We require the student to be an in-service paid health worker. That means this is full-time employee, and that in principle the operator or the manager of the home should grant leave for the colleague to take this course, and that means they were given allowance for, say, somebody to cover the relevant duties and for other colleagues to take overtime work, etc. As for the practicum, it will last for about a month, so that within a year you'll be able to complete the course. This is our design. I'll see if the Assistant Director has anything to supplement. Thank you, Chair. We encourage eligible health workers and homes to take part in this arrangement. The Social Welfare Department will introduce a subsidy scheme to subsidize eligible health workers to take this course. Like the Deputy Secretary said, it will run for about a year, including the part-time in-class learning as well as a full-time practicum. We also maintain close liaison with the sector. We have their strong support. They're happy to work with us. So in terms of class hours, they will try to fit the schedule as much as possible so that flexible arrangements will be put in place to facilitate the students in taking the classes. Right, a follow-up question, Chairman. So how much will a student need to pay for the course? And what is the expected amount of subsidy for the 60 places for the HCP course? Thank you, Chair. 2 institutions are qualified to operate the course. We attach great importance to the professional level of the courses, and that means we need a lecturer meeting the QF5 standard. And we've been discussing with the institutions. The tuition fee is around $80,000. We've told the institutions that we plan to fully subsidize the fees, and that each candidate will be, for each candidate taking the course, the home will get $40,000. So that during the 7-week practicum period, they will be given the subsidy to hire substitutes or to make payout for those working overtime, so that the operation will not be impacted upon. Some members would like to speak for the second round. Professor Chan, 3 minutes. Yes, a point of clarification. We have been discussing ENs and HCPs. And I'd like to know if there is mutual recognition or interchangeability of these 2 roles. So my question is this. There should be separate roles for ENs and HCPs, because nurses are trained in the healthcare setting. For HCPs, they are trained in a residential care home setting. Is that true? If that is, that means we should let the public know squarely that the HCP works in a residential care setting under the Social Welfare Department. It's not the same as the professional qualifications of an EN. The second point is for CPD, there will be elements relating to residential care homes operation. I think we should introduce a CPD requirement, because in the laws we do make provisions for, say, the number of hours of CPD for regulation. So this should be included. Third point, to pick up on Mr. Lam Chun Sing's question, if a candidate has a nursing qualification in the mainland without the similar qualification in Hong Kong, then will this candidate be eligible to take this HCP course in order to address the manpower shortfall. Undersecretary, I will answer the third question about those with mainland qualifications or qualifications recognized in other jurisdictions. We first require the recognition of such qualifications from the Hong Kong CAAVQ. Say if this candidate graduated from the mainland, then there should be a graduate certificate, for example, for the HKCAAQ to verify. And as for the qualification requirement of HCP, it's Form 5, is that right? Secondary school leavers. So basically, they will be meeting the academic requirement, but then at the local level, it may be difficult to verify that graduation certificate, and it's really a pity because otherwise, if you have this certificate, we should be able to provide accreditation. Let me explain the difference between HCP and EN. HCP is a rank for the social welfare sector. Is position designed for health services in the residential care setting is different from the EN. So HCPs cannot work in a hospital, but EN, however, receives more comprehensive training. So they can work in residential care homes because procedures are simpler and they've been trained. So the position is clear. As for CPD, in the amendment regulations, we empower the director to put in place CPD requirements. But after all, this is a new arrangement. Upon graduation of the first batch of HCPs, we will have regard to the experience and see if CPD conditions should be introduced. Please give us time to observe the situation. We will consider that. As for the mainland nurses, I think Undersecretary already explained that.
If there are no further questions for the policy, then we move into clause-by-clause scrutiny. Please note that on June 5th, the legal advisor has written to the administration concerning drafting issues and so on and so forth. And the administration has come back, and it is paper 04. And during the course of the scrutiny, I would like to ask the legal advisor to remind members of the relevant legislative drafting points. And if necessary, members can make further comments when the administration seeks to give a response on those points. We'll first of all look at the Chinese versions of the two draft amendment regulations. And of course, if you have any points concerning the English version, you can also raise them. And so please refer to legal notices 65 and 66. We will look at the two markup versions, paper 02, and also subsequently to look at the other provisions under the amendment regulations. Okay, so over to you, administration. Members, let's go into clause-by-clause scrutiny with regard to legal notices 65, 66, clauses 1 and 2. First of all, effective date. The two legal notices both say under 1 that most of the provisions will come into effect on October 14th, and the proposed effective date has already taken into consideration the 14 required days for legislative scrutiny by Legislative Council, and if necessary, to further extend it to 21 days, and so on and so forth. And secondly, some of the staffing requirements concerning higher level care residential homes will come to effect in 2028. And legal notice 65 sets that it will come into effect in August in 2026, and subclause 2 and 3 says that the amended subclause 15 will come into effect on a date specified by the Bureau Secretary. As for bracket 2 sets that the amended regulation bracket 4 and 6 will come into effect on June 6, 2028. And bracket 3 says that 13 and bracket 5 will come into effect immediately after a date specified by the Bureau Secretary. And we will give further explanation when we come into clause 13. And then clause 2 of 66 legal notice says that for cap 459, cap 8 is subject to amendment. And bracket 2 says that we are amending the RCHD ordinance cap 163. Okay, now we go to the remaining provisions. Please look at legal notice 65 pages 1 to 3 and pages 1 and 2 of legal notice 66. Now, if the provisions are the same, then I will read them out at one go, and if they are separate, then I will read them out separately. Now, number 3 is interpretation. It is to add to cap 45 and 613 interpretation provisions to add in the definition for HCP. And also, correspondingly, we have revised the definition for health workers and care workers so as to include the new profession of HCP. And 63 of legal notice 66 also add in definitions for RNs and ENs, so that original 613A definition for RNs and ENs are amalgamated and incorporated into this new definition. Now, clause 4 of the 2 legal notices is pages 45 of 65 legal notice and 3 to 4 of 66 legal notice. And it seeks to amend 3B of 4, 5, 6, and 613 cap. And we will be added in the HCPs as eligible for registered managers in terms of career progression. Next is pages 6 of legal notice 65 and page 5 of legal notice 66. Once again, this has to do with the tenure of registered managers. And this is to replace the word still in cap 459 and 623. And so this is to clarify that the amendment will reflect that when tenure is being renewed, it has to give regards to the prevailing requirements, and it doesn't change the intent. Now, legal notice, page 7, legal notice 66, page 6. And so this is clause 6 of the 2 legal notices, and the amendment is to give effect to the arrangements maintaining the validity of the registration of a registered managers during the period when tenure is being renewed. And we want to bring the Chinese version and English version in line with each other to mean that it's up to the director's discretion to determine this. Now, Clause 7 of the two legal notices is page 7 of legal notice 65 Chinese version and Chinese version page 6 of legal notice 66, and Clause 7 is to amend 3N of Cap 45 and Cap 613 to add HCP to be on the eligibility list for provisional register managers. So this is the same as the aforesaid amendment to Clause 4. Now, Clause 8 is to amend 3 S1B of Cap 45(9) and 613 is to add by the director to the English version. That is the validity of the registration of a register manager during the course when that register manager is seeking renewal of his tenure will remain intact. Mr. Lam, any question from you? Now concerning 0003 of markup version, 003, Cap 459. I would like to clarify one point. So to add in HCPs for bracket B, nursing care services that may be provided by an enrolled nurse to residents of a residential care home. On the face of it, it's okay. However, I just want to clarify that the enrolled nurse that is providing service is actually not a registered HCP. I just want to look at it the other way around. So this means that it's an enrolled nurse, not a registered HCP. So this is number one. Number two, here it specifies that the service must be performed by an EN or by a registered or by an EN. Does it mean that the registered nurses cannot perform such a duty? Because under relevant nursing ordinance, they each have their own respective line of duties being specified under the ordinance. So is it possible for a registered nurse to perform a lower level of duty? Actually, it is possible for a higher level of nurses to perform lower level of duties, but not the other way around. Okay, so that's clear. So now we have come to Clause 8 of the two legal notices. We move on. Now Legal Notice 65, Clause 9. Legal Notice 65 is to add in 2B to Cap 459. Cap 459. And for Legal Notice 66 is also to add in EB. And this is to set up the registration system for HCP. The new provision is 3EZ to 3EZN. So this is to take reference to the present regulatory regime for health managers as well as health workers. Now, if you look at pages 9 to 10 of markup version for Legal Notice 65 and pages 8 to 9 of Legal Notice 66. The newly added Clause 3 is to lay out the conditions and the method of application for HCPs. And EZEA says that if the director is satisfied that the required qualification is already possessed by the applicant, then he can give qualification to the applicant to become an HCP, and also HCP applicant demonstrates that he is capable of performing duties, then the director can approve the application. Legal advisor has got a problem.
Thank you, Chairman. 3ZE bracket 2 bracket A and then Roman 1, it provides the qualifications specified by the director. Now, in both legal notices, the qualifications are not spelled out. According to the administration's reply to our letter, we understand that the administration refers to a professional diploma program for HCP, which will be announced on the website of the Social Welfare Department. We also note that in relation to the qualification requirements for the registered home manager and health worker in 459A and 613A, the requirements are spelled out. Since the HCP will form a crucial element in the framework, will the administration consider including the specific requirement, and that's the professional diploma course for HCP in the provision? Thank you, Chair. Let me explain. The legal advisor has correctly pointed out this observation, but I want to explain the policy intent. The HCP is a new rank. Apart from academic qualifications for enrollment, there is also the work experience requirement, and that you need to have 3 years of experience for admission. In fact, this is something that we have been considered or will consider in the future, because there are views that for fresh graduates or those without experience, they should be allowed to take the course as well. And in fact, some members also refer to greater flexibility and do allow the administration some flexibility in imposing the qualifications requirement. We will make sure that this is published in the public domain so that there is no misunderstanding. But then, since this is something new, we want to wait until a few years so that we can gauge experience and see whether the director should expressly provide for the requirements. We will report to the Legislative Council in the future. We are not putting this in at the moment because we want to see how it goes. In other words, you want to allow the director discretion, right? But the Deputy Secretary, at the same time, you've also undertaken that if there is any change, you report back to the panel. Right. Please go on. We now go to 3ZA and 3ZB of the two legal notices. These two provisions refer to the director's consideration of whether the person is a fit and proper HCP for registration, and also a requirement for the director to inform the applicant of the decision. And then Z3CC and 3ZD, notice of decision for renewal of registration as registered HCP, as well as things that the director should consider in this process. 3ZE, registration remains in effect pending determination of renewal application. Professor Chairman Kong. Thank you, Chair. I see that this decision will be made by the director. Does it mean that this is too wide a vacuum for the director to decide everything? But after all, this is a piece of legislation, and the HCP is a professional rank. If you leave everything to the director, then will there be a problem? Say for 3ZF, the validity period must not exceed 5 years. For enrolled nurse or registered nurse, the registration is subject to renewal every 3 years. Well, if you want to give flexibility to the director, then the way this is drafted, in my view, is too vague. So can you explain? Say, for example, what will be left to the director and what not? Because now it seems the margin of discretion is too wide, and there may be a succession issue when it comes to the decision of one director to the next. Yes. Well, we have tried our best to set out all the requirements with great clarity here. Of course, the director has discretionary power. It doesn't mean that the director is not subject to any straitjacket. Internally, we have established procedures as well as the code of practice, and the decision of the director will be subject to judicial challenge as well. I want to explain when it comes to regulation that there are two ways to go by it. Either we ask the profession to practice self-regulation, or the profession will be subject to regulation by the government. Say for doctors, nurses, they practice self-regulation. But there is more we need to consider. In terms of complexity of the duties and the level of the professional level of work, having regard to the nature and the task involved, I don't think that HCPs should go by professional self-regulation, but rather they should be subject to a regulatory framework. Like I said, the director's discretion is not limitless. The Legislative Council will also monitor how this power is exercised. So in other words, this applies to existing residential care homes as well. Only that for this new position, likewise, the director will have similar discretion. We now come to 3ZFGH. 3ZF. Validity period of registration will be decided by the director and must not exceed 5 years. That applies to both legal notices. 3ZG, 3ZH. Likewise, under certain circumstances, the director may revoke the registration of a person as an HCP, and that the decision of cancellation should be made notified in writing. There is also a requirement for the date and time of cancellation to be spelled out. Mr. Andrew Lam. First on renewal. In theory, the academic qualifications of an HCP should not change after registration. But then, if we take a look at the original provision, 3B bracket, is so complex. That means before making the application, this person should have been working in one or more residential care homes within 3 years, and that this person should also have worked in the homes for a total of at least 5 years. So what if there is a gap in between? How does it work out? If you say that you follow the existing mechanism, then do tell me how this is done, since we're on this provision on registration. I'm sorry, Chair. I want Mr. Lam to clarify whether he's referring to registration of home managers or registered HCP. For registered HCPs, we do not spell out the years of experience in the proposed amendment. Then that's a big problem, because this is a provision on renewal. I think Professor Chairman Kong made a valid point just now. Frankly, you want to make things flexible for the director, but after all, we are examining legal provisions. Say if the validity period of registration or renewed registration is one of 5 years, then how do we count the number of years? If you say this is to be left to the director, then it's far from ideal. I think your question was, what if there is a gap? Must that be in continuous service, for example? Because we cited another provision, and that seems to be clear. I want to know if the same goes for registered HCPs. I'll try to understand the question. For home managers, we do require this candidate to have acquired sufficient experience before taking up this position as a home manager. We don't want somebody without any experience to become the manager there and then. There must be years of experience. As for HCPs, the nature is different. It's not a managerial role. It's not about managing a big establishment or the whole care home. So the director will set the relevant requirements through administrative means. So I'd say that we cannot make this direct comparison. For home managers, the requirement is that there should be years of experience of operating a home. For HCPs, it's different. Well, you've told me the difference, but you can't explain to me why. Because frankly, I can just work for 3 months and then I can apply for registration for 5 years. But you explained in the beginning that you don't want people to get the qualification and not joining the sector, because you want to have a stable stream of manpower supply. Let's say if the validity period runs for 10 years, then will you allow a renewal of registration? You need to explain the criteria to us. Right, requirement for registration or renewed registration as a registered HCP. The requirements are very straightforward. This will be considered and imposed by the director, but it's not part of the law. Well, academic qualifications, yes. We're going to specify the requirements. I think you've given me an answer. Academic qualifications, yes, but years of experience, no, not in the legal provisions. This is not under the director's consideration, or at least you're not able to explain that at today's subcommittee meeting. Chairman, if I may, well, this is subject to change in the future, but we do lay down requirements. For example, for in-service, to be registered as HCP, this candidate should be an in-service health worker with 3 years of experience. We also explain about the academic qualifications, but this is not our end game. For in-service health workers applying to study this course as HCP will observe, and after a while we want to widen the talent pool and we want to, say, relax the requirement for fresh graduates or for others who'd like to switch fields. Maybe we will remove the 3-year requirement, or maybe we will shorten it to 2 or 1 year. And administratively, the director will be given flexibility to make this change. But if we expressly provide for the requirement in the legal provisions now, then despite having provided, say, a validity period of 5 or 3 years, etc., by then we'll need to kickstart the negative vetting process again in order to make a change. And we want to keep things flexible. It's all right to maintain flexibility, but if you tell us that you want to keep all options open policy-wise, then you can say not more than 3 years, for example. Any response? 3 years is just our preliminary thinking. Say we need to see how things go. If it's not ideal, we may need to lengthen it for 4 years or 3.5 years. It's something new. So we want to keep things flexible when it comes to qualifications requirement. Now, I don't want to go back to a policy discussion because we're examining the provisions, but my feeling is that you don't have a positive response to my point. Now, if there is no policy direction, we don't know whether you are taking the stringent path or otherwise. Now, I need to be stern, but I don't think this is ideal. It involves renewal of registration. If you just tell us that pass the amendment regulation and then the director will then take the helm and then we'll go by negative vetting again, then if you ask me if I'm satisfied, I'll say that is not to my satisfaction. Let's see if there are other views. I have scrutinized so many similar pieces of legislation, not so much relating to professional self-regulation, but on recognition of qualifications, including work experience and education attainment. I don't think it's ideal if these are left out in the law.
It's not like that we don't have a direction. The present proposal is 3 years of experience and clear-cut academic qualification required. And so this is clearly laid out. We do want to leave room for amendment or modification in the future. And then if we do so, then we have to go through negative vetting. And the legal advisor has already heard our explanation. We are proposing this because we want to give discretion to the administration so that in future there might be room for qualification to be further relaxed so that more people can join the ranks. So it's not like that we don't have any direction at all. It's only that we want to break it down into 2 steps or 3 steps. The first time you answer my question, you say that you want to relax so that it's no more than 3 years. However, subsequently you said that you may at the same time tighten the regulation or requirement so that it becomes 4 years. And so if that is the case, then indeed you are lost. Do you want to tighten it or relax it? I think the present provision already says very clearly that an HCP has to be qualified as defined by the director and has to be fit and proper person. And at present, that qualification and eligibility comprises 2 parts. First, 3 years of experience already accrued as existing health worker, and secondly, has already completed certification course for HCP. We also require the relevant academy to abide by the same criteria when admitting trainees. So the admission requirement for potential trainees is also for 3 years of experience as healthcare workers. And we will spell this out very clearly for the benefit of healthcare workers and whoever might be interested in becoming HCP. Okay, for renewal, If the requirement is 3 years of experience, what about there is a break in the service? Is it 3 years of continuous experience, or can breaks be allowed? So can you clearly spell out what is the requirement for renewal? Let me explain it this way. Now, if we propose 3 years, and if there is no amendment, then the same system will apply upon renewal. So if first registration is subject to this requirement, then for subsequent renewal, it will also be subject to the same requirement. However, the administration also want flexibility to further modify this in future if circumstances allowed. Now, if the Bureau is clear, but I'm not clear, then it may be because of my stupidity. I just want to clarify what's going to happen upon renewal. Now, if you give discretion to the director for first registration, then you should then be also giving discretion to renewal. And you want a room to tighten it or relax it in the future. Okay, so let's take it that this is your proposal. Now, if they are registered for 5 years and upon renewal, you discover that this person actually has only worked for 1 year as HCP, but and then has had a break of service of 4 years. Now, that kind of renewal, will you be allowed? Will you allow it? Will that kind of renewal be allowed? Is that allowed at all? Indeed, 5 years is the validity of the registration. It doesn't mean that he has to complete all 5 years of service. Maybe he has taken 2 years for a vacation, and he has only worked as HCP for 3 years. After registering, a person doesn't necessarily have to work as HCP. However, upon renewal, then we have to make sure that he already has had 3 years of experience. So upon renewal, he also has to meet the original requirement for first registration. So if a person is on a job as a health worker for 3 years, then he can sit for the certification course. And after he has gotten registration, then he's eligible to be an HCP for 5 years, but it doesn't mean that he has to work as an HCP for 5 years. He can take 2 years out for vacation, for example. Okay, I try to see if I understand this clearly. So he is registered for 5 years. If within those 5 years he has worked for any of those 3 years, then he is eligible for renewal. Is that the case? I really want to make this very clear because this is supposed to be a piece of legislation. And the 3 years is not continuous. So any 3 years out of a 5-year period. It doesn't have to be continuous 3 years. I think the Deputy Secretary is smiling, so he should be confident. But I just want to put on record that we should make this very, very clear. I'm sorry I've taken so much time, but I really failed to grasp the intent of the administration previously, because a lot of the legislation in our books is worded differently and interpreted differently than this. We only have 5 more minutes. If you do not mind, do we extend our meeting by another 30 minutes? For now? Yes, Mr. Leung? Sorry, the speaker is speaking off mic. I can stay till 5. Right. Mr. Chen Wing Kwong? Maybe I'm stupid too. I want to look at 3ZF. Validity period for a registered HCP, it says it is determined by the director and no more than 5 years. no more than 5 years, and to be determined by the director. So, for an HCP to get his license renewed, how many years of service has he had to rendered? So, is that determined by the director? Is it 2 years of service out of 5 years or 3 years of service out of 5 years? So, is a license subject to renewal after 5 years? Say, for the first batch of registered HCPs, do they need to renew their licenses 1 year from now, or 3 years from now, or 5 years from now? Does it mean that there is a different registration time for each batch of HCPs? And also, what criteria do you base your judgment on in determining whether they should be renewed? Is it years of service, or is it performance, and so on and so forth? So, as things are worded right now, I think it's very, very fussy. And so I'm in the same boat as Mr. Lam Siu Lo. Say, upon graduation, after what number of years does that HCP course graduate has to get registered? And is the registration time for each HCP is different? And what is the requirement for renewal? Is it entirely up to the discretion of director without any requirement for continuing education, or without requirement for any number of years of service? You are talking about the validity of registration, and the validity period of registration will be the same for everyone, right? If it's 3 years, then it's 3 years for everyone. It will not be up to the discretion of the director. The provisions, as worded, say that the managers and health workers actually are subject to the same registration method. And the provision says 5 years, and that is the validity period for the registration. Why is it that in certain cases it's less than 3 years? Let me explain. For someone to be eligible to be HCP, that person has to pass the certification course specified by the director. And apart from that, the person also has to demonstrate that he is a fit and proper person and is capable enough to perform the job. And that has to satisfy the director. And also he has to tender a registration fee. Now, why is it that the provision says 5 years? Whether it's renewal or first registration, the SWD will require the applicant to come before the SWD to sit for a written test and a capability test and an interview. So through such steps, we'll be able to get a accurate gauge on his capability. And the test will cover the lines of duties or duties to be performed by HCPs. And if that person passes the test and we are satisfied, then he can indeed be an HCP. As for fit and proper person condition, we will require the applicant to go to the police department to get his criminal record, and we will look at his criminal record to see whether he is eligible to be an HCP. And also, we will look at the duties performed by an HCP in the line of work. In the case of renewal, we will assess whether the HCP on his performance in the line of work. So the validity period for registration is usually 5 years under the provisions. However, in certain cases, the registration validity period might be less to reflect his capability or his performance. If that is the case, then that has little to do with professional consideration. To put it simply, the director can actually determine the length of validity of HCP's registration, correct? To put it frankly, if a person meets all requirements, then it will be 5 years. However, if an applicant shows up short in performance or track record in the past, or is falling short of certain requirements under the fit and proper category, then the registration period might be shorter, so that we can give him an incentive to make up for his shortfall. Then the director will be super busy because the director will have to look at each case one by one. Of course, the director will devolve such assessment to the licensing section. And every time an HCP wants to renew his license, he will have to come before the licensing section to demonstrate his capability and suitability.
Then why don't you draw a code to spell out, say, the CPD requirements, the assessment criteria, etc.? Why don't you spell everything out? Because instead of putting down 5 years here, you can put down 3 years in order to strike a better balance. For other professions, it's usually a validity period of 3 years instead of 5. Why should you put down must not exceed 5 years here instead of just specify 3 years? Now, can you tell us whether there are other provisions adopting the same practice? For home managers and health workers, we also use the same registration and renewal mechanism. It is an effective and established practice. Yes, Chairman. Likewise, the validity period of registration and renewed registration for registered home manager and health workers is likewise not exceeding 5 years, so it's in line with the existing arrangement. Now, may I invite members to turn to Legal Notice 65, marked up copy, page 10, 3ZC. Say, the application must be made to the director at least 3 months before, but not earlier than 6 months before the expiry of the registration. And this application refers to renewal of registration. And then the director will consider whether the registration requirements are met before granting the renewal application. And that's the crux of our discussion on the 3-year period. And then subsection 43Z(c), the director may impose on the renewed registration any condition that he considers appropriate, including the element of continuous learning, albeit not in the exact wording of CPD. Well, Chairman, just the last point, we've been looking at this piece of legislation and we find a major problem here. If there is no major change, if the same applies, that the director has great discretionary power, then why do we need to amend the regulations? Administration, I'll try to answer that question. HCP is something new, that's all. Like Mr. Leung said, we started from scratch. We didn't have HCP. It doesn't exist in the law. So it's a new rank. In order to establish a new rank, we need to have regard to the regulation of other ranks in the residential care home sector. For example, we have health workers and home managers subject to a regulatory framework, And in fact, we copied the same framework up to 99%. And that's why for the validity period of registration for HCPs is 5 years. Now, Chairman, you may recall before the amended ordinance came into effect in 2023, for health workers, after acquiring that status, is a lifelong registration. And then you could carry yourself as a health worker without actually engaging in this line of work. So after discussing with the LegCo, then we proposed to set up a 5-year registration period, and that for each registration it must not go beyond 5 years, so that only those dedicated to social service could get this qualification. Members may have this recollection. For health workers or the newly established HCPs, if they don't perform well in the sector, you can put in place an observation period for, say, 3 years instead of 5, so that they stay vigilant. Thank you, Chair. Now I get it. It's not about professional registration. It's just it's just job description. Just spell this out. I would just say that the drafting style is ambiguous. Oh, Professor Chan, I think the administration has already explained. We tried to compare the registration systems of an HCP and the registered nurse, but in a residential care home setting, we cannot make this direct comparison. Perhaps because we have continued to hear the same title, enrolled nurse, and we want to make this comparison, but in fact things are clear. Mr. Denslow. Another follow-up question. The explanation I heard is clear enough. But in terms of registration or renewal registration, there is a starting date and end date of the validity period, which does not exceed 5 years. I want to go back to 3ZC bracket 2 bracket A. Before the end of the registration period of the first batch of HCPs, if they want to apply for renewal, they need to do so at least 3 months before, but not earlier than 6 months before the expiry of the registration. So, does it mean that if the application falls within the 3-month period before expiry or earlier than 6 months before, then the application will not be accepted, and that one must first apply for registration instead of renewal according to 3Z. The second question is 3Z bracket 3 and then 3ZC bracket 4 about registration and renewal of registration. In bracket 4, the director may impose relevant conditions that the director considers appropriate, including continuous learning. So is it that even for the first-time registrants, the director may already impose a continuous learning requirement? That means the candidate must complete the continuous learning for within the certain time frame. Can you explain the time frame? And is it a prerequisite for renewal? That is a CPD requirement. Who would like to take this question, please? About renewed registration, the law makes it clear that at least 3 months before, but not earlier than 6 months before expiry of the registration, the HCP should make an application for renewal. About the condition to be imposed, this provision empowers the director to make a decision on what conditions to be imposed, one of which could be continuous learning. Right, my question is, if the application for renewed registration falls outside the scope mentioned, does it mean that, say, at the lapse of the period, you cannot ask for renewal? Instead, you need to apply afresh for registration? True. So, for the first time registrants, they can also be subject to conditions. Do I take it that this is a prerequisite? That means no matter the conditions, one of them must include the continuous professional development condition. Chairman, that's not our interpretation. We call it an option. It's one of the conditions that may be imposed. Chairman, in that case, may I ask the administration to go back and seek advice from the DOJ? Because it seems to me that the director must impose the continuous learning requirement. Otherwise, you should put down one of which relate to continuous learning instead of including any condition relating to continuous learning, at least in Chinese. Please double check with the DOJ. The policy intent is that a condition relating to continuous learning may be imposed. Perhaps I'll give the floor to the DOJ to explain the provision. Who would like to take this question, please, Ms. Tong? Thank you, Chair. 3ZC bracket 4. The director may impose on the renewed registration any condition that the director considers appropriate, including any condition relating to continuous learning. So that means conditions that the director may impose, for example, a condition relating to continuous learning. Is not the case that the condition which the director considers appropriate must relate to continuous learning. So reading the whole paragraph, you'll have a clearer idea. Let's go on. Three ZI, 3ZJ in both legal notices. It provides that if the person's registration or renewed registration is refused or cancelled, the person may appeal to the Commissioner for Labor and Welfare, the Secretary for Labor and Welfare. Next. 3ZK. Similarly, the registered HCP should report certain events to the director. 3ZL, 3ZM requires the director to keep a register containing a list of registered HCPs to ascertain whether a person is registered as an HCP and the registration details. The director must also make available the register for public inspection at the government offices. The legal advisor has a question about 3ZK, mandatory reporting of certain events. This relates to the director's consideration of whether a person is a fit and proper person to be registered. According to the existing mechanism, if this applicant is involved in a summary offense involving fraud or dishonesty or offense of a sexual nature, say under Cap 459A or 613A, if the applicant has made a false declaration of misrepresentation, thereby committing an offense, then under the current legislation, there is no need to report such an event under 3ZK. So to align the practice with 3ZA, you should add this bit in for the director to consider whether this is a fit and proper person to be registered. Yes, director? Let me explain. This arrangement is the same as that for home managers and health workers. Now, members, as background information, in 2023, when we proposed amendments to the ordinance, some members mentioned that minor offences should also be reportable, such as littering, jaywalking, illegal parking. I mean, the way we drafted the provision, these minor offences would be captured as well. And after discussing with the Legislative Council, we decided to draw a line at indictable offence so as to strike a balance. So that's a consensus reached with the then Legislative Council, and we have not proposed anything new. We followed the same practice. Please continue. Mr. Lam Wai Kong, you have a question? To report certain events under 3ZK, what's the penalty for failing to report? What would be the consequence? DS? Is a breach of the law for failing to report. The director can cancel the registration or refuse to renew the registration because we can take enforcement action. So if the HCP does not make this report, or during a review the director finds that something has not been reported, then is it that the registration will be revoked immediately? Is it that there is no need to inform the HCP of the cancellation in writing, for example? There is a specific provision on cancellation of registration. We'll come to that in a moment. Chairman, let me also supplement. You will find the cancellation provision in 3ZHG. 3ZG, page 12 of LN 66 or page 13 of LN 65.
So you can see 3ZG3. ZG1C2, violation of section 3ZK, and 3ZG2 and 3 says that if the requirement is not met, then what methods will be used by the director to cancel the application. So it's specified there. Please move on. Now it's section 10 of the two legal notices concerning registration of health workers. To delete still in the original Cap 459 and Cap 613. And these amendment is to add to the clarity of the wording without changing the original meaning. Now, clause 11 is the same as amendment of clauses 6 and 8. It's to add in by the director under 7C and 1B. So this is relevant to the period when a health worker is seeking renewal. Now it's clause 12, staffing requirement. Please look at page 22 of Legal Notice 66. original provision 11(1)(a)(c), at least one member of the care staff for every 3 or less than 3 beds in the nursing home, and we change it to or one health and care practitioner. This is to follow international practice and to take reference from the usual staffing level of residential homes in Hong Kong. And 11(1)(a)(c) is to add in or one health and care practitioner, so that the homes can engage HCP to meet staffing requirement. As for staffing requirement for nurses, it remains unchanged. And then page 23, it's clause 12, 3 to 5. We delete D paragraph and we replace it with a new D paragraph. And the requirement for health and care practitioner is freshly expressed. And so this is to give effect and power to the administration to regulate the engagement of HCP. Please, page 21 of Legal Notice 66. Now this is to amend 11(2) and B, and this is to streamline the expression of the Chinese version. And also there is a new format for 13CD, and to add in paragraph B. And so this is arrangement for engagement of HCP. And also we have a new 11(2)E, and we have changed registered nurse to enrolled nurse. Mr. Leung, I can see that you are now seeking to upgrade the health workers to HCPs. However, for registration, only health workers, registered health workers, can become HCPs. But have you given regard to any possibility that when there is insufficient health workers, you might require HCPs to be health workers? Because whether it's paragraph D or DA, you have to make sure that health workers must be filled by qualified health workers. Because HCP is supposed to be of a higher grade, and so it has to be registered HCP. However, in the market, there may be a shortfall in the supply of HCPs. Maybe a person has already completed training and is already registered as an HCP. However, there are insufficient HCP positions, then he may have to move a step down to work as an health worker for the time being. So is it possible for a registered HCPs to be a health worker, to come down one step, to come down one grade? The system will allow a registered professional to come down one grade. We will look at the contract. We will look at whether the residential home is engaging him to be a health worker or an HCP, and to look at the line of duties that the person has been performing. If a higher grade professional, say a registered HCP, is to come down one grade to work as a health worker, that is allowed. Because D1 sets if someone other than a health worker is to be engaged as a health worker. So is it possible for an register HCP to come down one grade and work as a health worker? Indeed, according to the legislation, there is certain requirement for health worker. And so as long as an HCP fits the requirement for a health worker, then he can become a health worker. Once again, the requirement, you have to remember that the requirement for a person to sit for training for HCP is 3 years of in-service experience as a health worker. And so definitely an HCP is qualified to be a health worker. Now, 13 is to amend the minimum staffing requirement of Schedule 1 of the original legislation, so that residential homes can enroll nurses or HCPs to meet the minimum requirement. And for 13(1) of the 2 legal notices is to amend Provision 1 of Schedule 1, is to include HCP to be part of the staff of residential homes. And 13(2) is to add HCPs to add in to the title of the original legislation, and in order to regulate the minimum requirement for aged homes and also high-level care homes. Now, for staffing requirement, you are to add in HCPs. But for the original health workers, are they already part of the staff? Yes, they're already part of the staff. But you won't give it further interpretation under Schedule 1? Schedule 1, minimum requirement. Minimum staffing requirement, it already has a provision to regulate that. Okay, I move on. Now, 13(3). Of the 2 legal notices. Once again, to add in HCP to column 3 of the Schedule 1. And it says that for every 30 inmates, there must be 1 HCP. And so this is for Legal Notice 65 of Legal Notice 66. The wording is that for every 30 inmates, there must be 1 health worker. And it also provides that 1 ENs and 1 HCPs will be regarded as 2 health workers. And then 13(4) and 6. And this is to give regard to the new staffing requirement for high-level aged home care. This is to amend Schedule 1, Column 3. High care level home and also disabled home. No more than 30 inmates or no more than 16 inmates and no more than 19 inmates. What are the minimum staffing requirements for each? And HCPs under the amendment will be incorporated so that the residential homes are starting from June 16th engage healthcare professionals, HCPs, to meet the new staffing requirement. Right, we have only a small way to go, so if you do not object, we extend the meeting by another 30 minutes. Now, for Schedule 1(1) interpretation, for interpretation for staff, it says nurses. Does it mean it includes both ENs as well as RNs? Indeed, for high-level care home or care intention home, both RNs and ENs are eligible. The legislation provides that the lowest requirement is ENs. However, if it specifies RNs, it means that the relevant duty is of a higher level, requiring high level of expertise, and that's why it is confined to only RNs. Now, 1(2). Will come into effect in 2028 after the miscellaneous amendment regulation comes into effect. 13(4) and 6. Once again, it will come into effect immediately after 2028, June 16th. Now, 13(5). That is the new level of staffing requirement for care and attention home. Schedule 1, column 3, says that for high-level care home and high-level disabled home, when the inmates are below 90 or above 90, there are different staffing requirements. And once again, 13(5) is to add in HCPs so that residential homes by then can start to recruit HCPs to meet the staffing requirements.
Allen 65, 1(3). Section 13(5) will come into effect immediately after the date as appointed by the Secretary for Labor and Welfare. And then legal notice 66 again, section 1(3), as mentioned for 13(5), it will come into effect immediately after the date as specified by the Secretary for Labor and Welfare. And then we come to 3(7) and 8 of the two legal notices, and there'll be amendments to Schedule 1 and Section 4. That is for the aged home and the homes for moderately handicapped. There'll be a minimum staffing requirement, and then we add health and care practitioner as those who can be hired. And then Schedule 3 of CAP 459 and also Schedule 2 of CAP 613A will be amended. This is about fees of registration for HCPs, and the fee levels are in line with that for health workers. We've completed the clause-by-clause examination of the two legal notices. So, legal advisor, please confirm that the English rendition of the proposed amendments and the legal notices are free of irregularities. Yes, we asked the administration some questions. We received answers. We confirmed that there is no inconsistency between the Chinese and English versions. Right, members, if you want to propose amendment for consideration by the subcommittee, please submit the draft amendment to the Secretariat by Wednesday, 5 p.m., the 24th of June, so as to allow time for the administration to give a response in writing. Now, likewise, if the administration would like to move amendments as well, please provide copies in advance for our consideration as quickly as possible. We've completed the scrutiny of the two legal notices and the content of the amendments. Members, do we agree that the amendments can be circulated? The following documents can be circulated to members for comments. First, written views from the public and the administration's consolidated response, and second, the administration's response to issues raised at the subcommittee meeting in writing, as well as any proposed amendment from either the subcommittee or the administration. Right. We'll decide after circulating the papers whether there is need for another meeting. As for legislative timetable, according to the established practice, the subcommittee will need to give notice to make a report to the House Committee before the end of the notice period for moving amendments to subsidiary legislation. Now, if there are no other views from members, I will move a resolution at the Council meeting of the 8th of July to extend the scrutiny period of the 2 pieces of subsidiary legislation so that the subcommittee will have sufficient time to examine them and report to the House Committee. Right, any views? If not, then if there's nothing under AOB, then meeting's adjourned. Thank you.